title of my presentation is Liberty or Equality? Debating Emerging Clashes Between Religious Freedom and Government Mandates. Now, though religious freedom is deeply rooted in our constitutional system, today we see momentous new clashes over religious liberty and various government mandates aimed at promoting equality. We see this in the clash between over the federal contraceptive mandate and religious conscience rights. We see this in the clash over gay marriage and traditional religious conceptions of matrimony. We see this in the clash over new anti-discrimination initiatives and the autonomy of religious institutions. Now, underlying these clashes is an enduring tension enduring constitutional tension between principles of liberty and equality. And so to illustrate this tension and see how it plays out in contemporary debates and clashes, I'm going to employ a technique I often use in the classroom. It may seem a little strange, but I'm going to conduct a debate between two sides. This will be a civil debate because I like to present civil arguments to students. And so what I'm going to do is I'm going to present a debate between Mr. Liberty on this side and Ms. Equality on this side. And we're going to see how they construct their arguments with respect to these new contentious clashes. And then, of course, we're going to invite your questions and comments. So, without further ado, I want to introduce to you Mr. Liberty. Thank you very much. It's great to be here and to participate in this debate with my esteemed colleague, Ms. Equality. Now, why do we have a free exercise clause of the First Amendment? Because to the founders, our sacred duties were viewed as deserving of ultimate protection. And that conscience is from God and it should be protected. You should be able to live out your conscience, your sense of sacred or transcendent duties. And there were numerous heroes of conscience throughout the colonial era, like Roger Williams and Mary Dyer, who actually was hanged for trying to proselytize her Quaker faith. And Roger Williams called it soul freedom. And this, in some sense, was so central that it was almost like the first freedom. And in some respects, I think, religious liberty helped to create who we are as a nation. It was so foundational. And James Madison recognized this, looking at the history of persecution and repression of religious conscience rights. He basically said this in his memorial: the duty we owe our Creator, that transcendent duty, is precedent both in order of time, in other words, it's prior to even the creation of the state, and in degree of obligation to the claims of civil society. And so you don't give up your right to live by your own understanding of transcendent duties when you enter into civil society. And that's why we have a constitutional protection of religious liberty. And in some sense, I would argue that the key measure of a free society is the extent to which we don't force people to choose between their sacred duties and their civic rights or obligations or benefits. Now, I want to make another point before I turn the floor over to Ms. Equality. The judicial principle that best embodies a high view of religious liberty, that it recognizes this sense of transcendent duty that we have, is the idea of strict scrutiny. Now, strict scrutiny is the doctrine the court uses when it adjudicates fundamental rights like freedom of speech. And basically it says this: no right is absolute, of course, but it says that when government burdens a fundamental liberty like religious freedom, it must use the least restrictive means of achieving a compelling state interest. And in my judgment, that is the kind of doctrine that we need to protect religious liberty in the new era in which new equality norms are challenging religious conscience rights. And this is not to say that religious liberty will always win. It's not a trump. It just means that there's a balancing that has to take place. So that when government mandates, in the interest of good policy, perhaps, do burden someone's religious freedom, the government has to show a compelling reason in doing so, and it has to show that it's using a less restrictive means of achieving that. And so that's why I favor religious freedom, and why I, as Mr. Liberty, have something to say about these contemporary clashes. With that, I'll turn it over to Ms. Equality. Well, I appreciate being here today and being able to share my views with you about the momentous issues that this country faces. And I want to make the case for equality, because equality is a profound constitutional value and principle. And it argues, it proposes that no person be denied the equal protection of the law. The founders fought for it, and ultimately the Civil War and the Civil Rights Movement embodied it and realized it. The idea, as written in the 14th Amendment, that no person should be denied the equal protection of the laws. In fact, it's interesting because even when defending religious liberty, James Madison articulated that principle of equality. And he said, equality ought to be the basis of every law. In other words, no special treatment, no exemptions for religious believers, equality before the law. And drawing on social contract theory, Madison also asserted that everyone should be viewed as entering into civil society on equal terms. This is a central democratic principle. Equality before the law, equal treatment, equal protection. And that's why I'm going to make the case that our growing realization of the importance of equality, gender equality, equality on the basis of sexual orientation, equality on the basis of disability, is in fact a positive development that we should applaud. And those who make a case for exemptions on the basis of religion are undermining that principle of equality. Now let me illustrate this with a contemporary issue that I'm sure Mr. Liberty is going to refer to, and that's gender equality. The struggle for women to achieve gender equality in our society has been a mighty struggle, and it's not fully realized, as we know. And when the federal government passed the Affordable Care Act, on the basis of women's advocacy, healthcare professionals, the best science available, the law stipulated that women should have free access to all of the fundamental health provisions necessary to ensure equality, and that included all forms of contraceptive services and reproductive rights. Because without reproductive freedom, without contraceptive access, women cannot realize in society their full equality. And so that's why the Health and Human Services promulgated the contraceptive mandate, requiring all institutions and businesses to provide free, in their insurance plans, access to free contraceptive services. And as we know, religious actors, from businesses like Hobby Lobby to religious institutions, are seeking exemptions from this mandate. But make no mistake, exemptions undermine the principle of equality. Now, that's my argument. Okay, well, let's turn to the affordable mandate and see what actually is happening here. The federal contraceptive mandate actually comes down uniquely hard on particular religious institutions. Now, not all churches, not all religious communities oppose contraceptives. Some oppose some oppose none, some oppose many. So this contraceptive mandate actually comes down in a disproportionate way on some religious communities versus others. So ironically, it even undermines the principle of equality because it uniquely burdens Catholic institutions, some evangelical institutions, and so forth. And what it does is it conscripts civil society institutions to fulfill government mandates. And it does not actually apply the doctrine of strict scrutiny. In other words, if you want to protect liberty, the government should use a less restrictive means of achieving its compelling interest. And as Robin Fretwell Wilson, a great scholar of this arena, notes, the government easily could pay for free contraceptives on its own. It doesn't have to force religious institutions to violate their consciences in order to provide that service. And that's, in fact, what is happening here. The government, in its law, is going to force some religious institutions that have objections to sterilization, abortifacients, and contraceptives to either violate their conscience or be fined. And is that what we want? Is that actually what we want to have happen? I don't think so. And let me give you an example of this. Little Sisters of the Poor, likely going to the Supreme Court. Now, the Little Sisters of the Poor are a Catholic religious order of nuns whose special ministry is to serve the elderly poor. Now, this may seem strange, but the Obama administration's HHS mandate says that they have to sign a form designating their insurance company to provide contraceptive services to their employees. Contraceptive services to their employees, the Little Sisters of the Poor. They believe this is a violation of their conscience rights. They don't want to be complicit in this. And so they will either be told you're going to be fined, you shut down, or you comply. I don't think that's what we want. I don't think that's what we want. Well, that's a cute example. But in reality, the vast majority of the religious claimants are large institutions, from hospitals to colleges, major institutions that seek an exemption from this generally applicable law. That is a fair law. That makes sense. And in fact, the government has provided a broad accommodation of groups like the Little Sisters of the Poor. It does not require that their insurance plan pay for contraceptives. It just means that they sign a form that says that has to be provided by the system. And the groups still insist that that's a violation of their conscience. Well, I just don't buy it. But let me mention something else. If we start going down the road of providing this religious exemption or that religious exemption, we're going to have Swiss cheese law. Even Justice Scalia criticized the notion of providing lots of religious exemptions. Everybody has a conscience claim for something or other. No, we need equal treatment, equal application of the law. And we need it especially for gender equality. Well, let me just say this about that last point, and then I'll turn it over to Ms. Equality. The odd thing about this is if you take equality to the extreme, such that you don't even provide an accommodation of conscience rights for religious institutions, you end up burdening only some religious actors and not others. Because obviously there are some churches that are happy with contraceptives, don't have an objection. So that means they're kind of government-approved churches, aren't there? And then you have churches or religious institutions that are not government-approved. That, to me, is almost a violation of the Establishment Clause. The government is saying, well, we approve of certain religious institutions that are happy with a contraceptive mandate, but we're going to come down hard on those that don't. I don't believe in that. Well, I'm going to leave that discussion for a moment because I want to turn to an even a more dramatic example of the principle of equality playing out in, I think, an incredible way in our society, in a way that is realizing equality that we could not have conceived before. And that is equality on the basis of sexual orientation. And I applaud the Supreme Court's ruling on gay marriage. which basically articulated the principle of equality. Equal protection of the laws meant that everyone should have the right to marry, irrespective of their orientation. The Equal Protection Clause of the 14th Amendment, in fact, ensures, and ought to, the right to marry. And as we know, gay couples were prevented before this from enjoying the same benefits as other heterosexual couples: inheritance, visitation rights, social benefits. But I would argue there's a deeper level of equality at play in the gay marriage movement, which I applaud. And that's equal dignity. In fact, Justice Kennedy spoke about equal dignity as the grounding of his decision or argument. Because, after all, if gay couples are not treated with equality by laws and society, they're not, in a sense, being accorded the equal dignity that they should. And once again, as Mr. Liberty will readily acknowledge, religious objectors seek exemptions from this new regime. They want the right to discriminate against gay couples in their institutions. And this violates the principle of equality. It violates equal dignity. And so that, to me, is why I celebrate the new marriage regime in the United States. This is a momentous issue. And in fact, the Becket Fund for Religious Liberty actually sponsored a major book and symposium looking at the tensions between gay marriage and religious liberty. And here's what I would argue. We had a broad, healthy, democratic deliberation going on in many states, as states were passing gay marriage statutes, providing accommodations of religious believers to win approval for those gay marriage statutes. Democracy was working. Growing toleration was the order of the day. What will now happen that the Supreme Court has mandated gay marriage for every state? Those who oppose, or those who wish to live up to their own transcendent understanding of matrimony, Catholics, some evangelicals, Orthodox Jews, others, will be treated as wanting to discriminate, and will be treated in a sense in the same way racial bigots have been treated. They could potentially lose their tax-exempt status if they don't provide married student housing at a college. Certainly, we already know that businesses that have refused to serve gay weddings have faced stiff fines and anti-discrimination laws. And here's what I'm concerned about here. This is a threat to civil society, which is so vibrant in the United States, a threat to charities, colleges, adoption agencies, and so forth. And something will be lost if we don't provide some room for people who still adhere to a traditional view of matrimony to live out their values. And let me give you an example. Catholic Charities ran a celebrated century-old adoption program in Massachusetts. It specialized in placing hard-to-adopt children, older children, racial minorities, handicapped. And everyone in Boston said this is an important niche that Catholic Charities did. When the Supreme Court of Massachusetts decreed that there was a marriage right, they could not keep their license and refused to place place kids only in heterosexual couples. They said, we will be happy to refer gay couples to other adoption agencies, but they were not given that right, that accommodation, and so they shut down. Now, do we want institutions to shut down because we're asking them to violate their conscience? I don't think so. Well, do you want to allow religious institutions to blatantly discriminate against gay couples? That is the issue here. That is the issue here. And religious institutions should become a part of this new equality regime. So that would be my argument here. Now I want to just raise one final issue here for a moment. The equal application of anti-discrimination laws. There is, as we know, there are religious institutions, religious communities that discriminate against women. Or, in some cases, even against people with disabilities. Do we want to allow religious communities exemption from that? I don't think so. There was a case where a woman was working as a teacher in a religious school, had a disability. They fired her, and she wasn't able to access the Americans with Disabilities Act for relief because she was viewed as a minister, and there's an exemption for ministers from the application of these anti-discrimination laws. So we're still fighting battles for equality, and religious autonomy claims are going to undermine those things. Well, let me respond to this issue. Actually, we know the Supreme Court came down 9-0 in favor of the religious school in that case because they said we don't want the government telling you who your ministers should be. But I want to just raise a final issue. You know, a variety of religious clubs now are being banned from college campuses from official recognition, because, mostly evangelical, because they want to adhere to traditional teachings about sexuality. In other words, sex is only for married heterosexual couples. Now, they're perfectly happy to let anybody come to their meetings, but that's the criteria for membership. But under the new equality press, universities have been denying access to these clubs. Now, notice this. By pressing the equality to the extreme and saying you have to let all comers into your clubs, it ends up discriminating uniquely against only one kind of club. The only clubs that have been denied access have been evangelical Christian clubs. So ironically, equality can end up discriminating. Well, let me just end by saying this. Why should clubs on college campuses receive official recognition, access to money, access to rooms, if they discriminate? I don't think that's what we want. So equality is really the standard, and that's where I think our society is moving. And I would say we must preserve liberty of conscience, zones of freedom for people to be who they are. Well, we've heard from Ms. Equality and Mr. Liberty. And isn't it ironic that both cited James Madison in their defenses? Well, what do you think? Thank you very much.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.